indeed Aoife's presentation. Professor Aoife Nolan, Professor of International Human Rights Law at the University of Nottingham. She's the founding coordinator of the Economic and Social Rights Academic Network, UK-Ireland. She's provided expert advice to a range of UN, Council of Europe and other international bodies, including various human rights actors. So we look forward with pleasure and anticipation to Aoife.
Okay, well, thank you very much, and it's fantastic to be here, and it really is, I mean, it's exciting to be part of this process, so thank you very much for the invitation. It's been very exciting to read about what you've been doing in your other meetings, so I'm looking forward to seeing the outcome of this, but just to congratulate you on what's gone before. Now, so far, we've talked about, thanks to Liam and David, you've heard about what economic, social and cultural rights are, and you've been given a very strong overview of how they're protected under the Irish Constitution as it stands. Now, what I'm going to do is I'm going to take us away from the Irish context, and I'm going to talk about how other countries have addressed the kind of issues that you're looking at today, how and if, should economic, social and cultural rights be included? If so, how are they to be included in the Constitution? And I'm going to look at the whys and the hows of how other countries have given effect or not to economic, social and cultural rights in their constitutional frameworks. Now, as with any set of rights, there's a wide variety of models, and every country, including Ireland, is going to be affected by the particular historical, political, cultural and legal context of the country in question, right? And that's true of, it's not just true of economic, social and cultural rights. As you'll know from your deliberations already, it's true of constitutions generally, and it's true of constitutional rights that are not economic, social and cultural. And it's very much not a case of one size fits all, right? There is no fantastic gold standard model that you can go, yep, that works, we'll have that, thank you very much, right? It's much more complex than that. However, there are some factors that have had a strong influence on a large number of countries' choices of their models and approach to economic, social and cultural rights. And from what we've heard already, these are likely to play a huge role in Ireland should you decide to move forward with suggesting that ESCR should be incorporated. And the first one are international human rights standards that the country in question has voluntarily agreed to be bound by. And we've just spoken about some of them for Ireland, the International Covenant on Economic, Social and Cultural Rights. Another one would be the Convention on the Rights of the Child that we heard a lot of discussion about around the child, the referendum on the child in 2012. Now, the important one thing that you notice that in some countries, first of all, the language of those standards have influenced the particular standards that have been put in their constitutions, right? So for instance, in South Africa, which is a very famous model, you see that the language of economic and social rights provisions in that constitution are clearly linked to the international standards, right? Other countries, for instance, Argentina and Colombia, which have very strong economic, social and cultural rights frameworks too, have directly incorporated those standards. They've whole-scale brought them into their own constitutional framework, so they apply directly. But it's not just about the international, right? Because in exactly the same way as you would with any other area, when countries look at how they'll deal with economic, social and cultural rights, they look at comparative experiences as well, right? And of course, it makes sense to look at comparative experience. I mean, you don't want to be reinventing the wheel, right? I mean, there's examples of good practice, and there's examples of real and potential problems that you obviously any country would want to avoid in its own context. Now, where do you look? Frequently, the obvious one is countries that are already protect, as I've said. The other area that we frequently would look, and the countries frequently look, are countries. They looked at other countries that they regard as similar towards themselves, so whether politically, economically, regionally, historically, okay? And that's quite challenging for us in Ireland because, in fact, we historically would look at the US and the UK and Europe a lot of the time when we're talking about how we put right standards or different constitutional principles or how we'd interpret them. The UK and the US don't have economic, social and cultural rights in their national constitutions. The UK, as you probably have heard at this point, doesn't even have a codified constitution. It's a very different framework. So there's very little we can take from there. And the other challenge is looking to Europe is challenging, because a lot of European countries have very strongly established constitutional principles that have really important implications for ESCR protection in those systems, but that we don't have in our system here. And that, for instance, that would include a very strong work around the principle of human dignity and what that means in terms of state provision for, the provision that states must make in order to guarantee human dignity. We don't have that, which means that if we look at, say, countries like Germany or Switzerland, where those are big parts of their case law and their constitutional background, that isn't going to translate across very effectively. Okay, so just to be conscious that we do have challenges in terms of where we will choose to look for, where we would choose to look for ESCR if we went that way. Choosing a model, right? Key question, is the particular model going to meet the concerns that have led to a desire for constitutional, economic and social cultural rights in the first place, right? There's no point sticking them in to discover that they don't actually address the issues that we thought they would address in the first place, right? So, for instance, will the economic, social and cultural rights that are in there actually work as a tool of advancing the position of people whose rights aren't being given effect to? So, for instance, very basically, are the rights that might be considered being included, do they connect with the problems that, for instance, poor people or disadvantaged people in those countries face, right? Because obviously, if there's that disconnect, those rights are going to be of very little value to those who need them most. The other key question is, will it be manageable for government? And it was really valuable for me to come after David's presentation, because in fact, you will hear a lot today, I suspect later on, in the discussion about, pro or con about the courts. But what's very important to remember about any right, including economic, social and cultural rights, is that, as David said, economic, social and cultural rights are first and foremost a framework for the elected branches of government, right? Government has the primary responsibility to give effect to them. And on that basis, we really have to ask, would putting economic, social and cultural rights in the Constitution correspond with what you would want to see the government doing? Right, so that's very important. Does it set out an appropriate framework? The other thing is, you can put in rights, you can put in every obligation under the sun into a constitution, right? Realistically, all rights are to some degree aspirational, right? There isn't a country in the world in which I would say any right is completely, fully and totally realised, okay? There is a gap between a right being aspirational and the government being asked to do something that no government is capable of doing, right? So it needs to be aware of that. And that's something that's been a very influential factor in choosing models, making sure that government is given enough breathing space to be able to budget, to be able to policy make, etc., in a way that's sensible and of the maximum, in this case, common good, for instance. So you have to balance that. The other thing is the model manageable for the courts? And comparative experience is very important here, right? What works in some countries hasn't worked in others. What a model can benefit some groups in society and others not. And also an awful lot of it is about, will the courts actually engage with the model? How will they interpret the rights? And the way that models of economic, social and cultural rights are structured will have huge implications for what the courts can, can't, should, shouldn't do. Okay, so be aware of that too. Now, a word that you'll certainly hear later on today and is extremely important historically in discussions about constitutional ESCR is that of justiciability, right? And, lawyers bandy that around like mad and we assume that everyone understands. So just in case it hasn't come up, I'm just going to give you a quick definition, which is a justiciable economic, social and cultural right is one that is enforceable by the courts, right? And you've had an excellent example given to you by David, Article 42.4 on primary education under our Constitution as it stands, right? So we already have an example of that. And there used to historically be a huge debate about whether economic, social and cultural rights could be justiciable. And in fact, examples like Article 42.4 make it very clear that they certainly can be. So the question is, to what extent should they be? And that's another question that I'll talk a bit more about in a minute. What are the key approaches? Okay, and this is very important. I'm giving you a real whistle-stop tour. If you consider that, say, I was doing a quick scan yesterday that the right to health is in 123 constitutions, right? This is a very broad overview. But first of all, what do we see? You see a model where you see an inclusion of justiciable economic and social rights. So economic and social rights that are enforceable by the courts. And this is present in a growing number of national constitutions, whether it's in Europe, whether it's in Africa or the Americas. And in Europe, you've got Spain, Portugal, Finland, Hungary, Latvia, right? These are all countries in which social rights have been held to be justiciable, judicially enforceable in particular situations, right? And this has been a huge shift. There's been a real move since the 1990s towards including this kind of right in constitutions, okay? The second model is the model that we have already and of course we have a number of justiciable economic and social rights in our constitution, which David just spoke of, such as education. Second model is that of directive principles, right? We have it, and our model was, 1937 constitution was extremely influential. On the back of it, you see it in India, Ghana, and Bangladesh. Okay? A number of different approaches, but the point is we're not the only country that has directive principles. Those are just some. And finally, the third model is one that is very uncommon, and I'm actually just mentioning here very quickly so that you know that it might be an option. And that is one where you initially have economic, social and cultural rights that aren't justiciable, that aren't judicially enforceable, but after a certain period of time, they're deemed to become enforceable, right? And if you were to look at the briefing paper that I've given you, there's an example of an Indian case where there's a directive principle in the Indian constitution on education. And in the Unikrishnan case, the Indian court turned around and said, look, you've had 44 years, it's not a directive principle anymore, it's now enforceable. Right, so that was the court making that decision, but it is possible to envisage a constitution where, for instance, you have provision that a certain number of years down the line, directive principles become legally binding if they're not being given effect to. Okay? So, the advantages and disadvantages. Let's look at justiciable economic and social and cultural rights. Could I have my water, please? First of all, the advantages are, again, thank you very much, is that they impose broad obligations on government to give effect to economic, social and cultural rights in its law and policy making, right? If you have a standard that is justiciable in the Constitution, the government will sit up and pay attention to it, because the fact, as anyone would if there is a threat of follow-up action for non-compliance, right? So that's the big advantage of them being justiciable. You've got the stick of the courts. You've also got the provision of a remedy, which is extremely important, right? Because obviously the people who we are most concerned about when we talk about putting economic, social and cultural rights in place, having the rights being justiciable means that they can access redress or remedies through the courts. Also, something that can be very important about having justiciable economic, social and cultural rights is it's a way for society to say, we don't just value, say, freedom from torture, we don't just value property rights, we actually also value social protection. We also value the right to an adequate standard of living. So it's a big symbolic statement as well, okay? Concerns, and these will certainly be discussed about. There is concern reasonably about the potential for judicial interference with economic and social policy and budgetary matters, right? The idea is the minute the courts can look at anything to do with resources, they might go mad and suddenly there'll be no role for government, right? I mean, I'm being facetious, but that is the extreme version of the argument. And certainly, the way in which, in some countries, if you look at how courts have approached economic, social and cultural rights, it has created great difficulty for government in making kind of general budgetary decisions or, making reasonable policy decisions, because they've had to respond to a series of judicial decisions that are kind of constantly puncturing the balloon of their rational overall policy, or their reasonable overall policy. But the extent to that risk occurs, that isn't something that automatically happens with economic, social and cultural rights. It depends on the model. It depends on the role that is envisaged for the government and the courts, right? So it's not about the rights per se, it's about how the way it's chosen to give effect to them within the Constitution, okay? The other thing is the potential complexities of defining the scope of such rights. So remember, we came back to we talked about the unenumerated rights a couple of minutes ago. One of the reasons that the Irish courts are nervous of unenumerated rights is because there's huge scope for defining those rights. Now, if you define, like any right, if you define economic, social and cultural rights in quite a narrow, precise way, there is a lot less wiggle room for the courts. So again, that's not an automatic problem. It's just something like the potential for judicial interference you'd need to bear in mind if you were designing a model having decided you wanted to have justiciable economic, social and cultural rights. Directive principles, we already have them. They provide advantage, absolutely. They provide a guiding framework for government, and they don't limit government decision-making powers. So in theory, government takes a look at the directive principles, says, oh, that's what I must do, and does so, right? The other thing that they may do is that they may serve as a useful interpretation, useful aid in judicial interpretation of rights. So for instance, in India, the right to life has been interpreted very broadly in light of the directive principles in that constitution. That hasn't happened in Ireland, okay? But there is that possibility. Directive principles have been brought into account in Ireland when talking about the right to livelihood, but not very much otherwise. So just to be aware, there is that potential, but we haven't seen it here. You know, what are the problems? Look, they're non-enforceable. So the governments can completely ignore them, thereby rendering them meaningless, okay? And the other thing is, if I'm a person whose rights to economic, social and cultural rights have been violated, and I go to court and they say, sorry, bad news, yes, there's a directive principle, you know, no question they're there, but we can't look at this, then where am I left? In fact, they're not, to me as a right holder who's, you know, living in poverty or my rights are being violated in some other way, they're not worth the paper they're written on, quite frankly. Okay, I'm going to talk very quickly about the time delay because I really don't think, you know, you just don't see it very often. Advantages, sure, it gives a run-in time. It gives government breathing space before they become, you know, legally accountable through the courts for failing to give effect to rights. The problem is, it means that, again, there's no effective remedy for people who are suffering in the here and now from rights violations. And the other thing is, how do you determine appropriate time limit, right? When do we decide that actually we require the government to achieve the highest attainable standard of health, for instance? You know, it's complex. The idea of time, of having a time lag with any right is complicated, and it's the same in economic, social and cultural rights. So, how much time do I have left, Tom?
You're quite close to the end of it.
Okay, that's no problem. Well, I'll just go through this relatively quickly. So I want to finish by very quickly talking about, if you were to go with justiciability, what would happen next? Where would you go, right? I've said it all depends on the models. Let's talk quickly about the other models. I don't think you're likely to get involved in this today, but you might as well have it in your head what the options are, right? Now, the first model is that economic, social and cultural rights are to be progressively realised subject to the state's maximum available resources, but then particular groups are identified whose rights should be realised immediately, right? So I'm going to go back just very quickly. Liam has explained progressive realisation. If the state is obliged to progressively realise rights, it has to move towards the achievement of those rights as quickly and as effectively as possible, right? And that obligation is limited by the resources that the state has available to it. Okay? So that's under the first model, that would be the general model, but then the option would be to say, well, actually there are some groups for whom we're not prepared to have this kind of over time moving as quickly as we can. We want it done now. So for instance, if you looked at the Colombian Constitution, and in a number of others, children or people with disabilities are given specific priority, and their rights have to be given either immediately or as a matter of priority. So that's one option, that you have a general obligation and then a group-specific immediate obligations. The second one is you've got the general obligation, where normally overall economic, social and cultural rights have to be progressively realised within the resources available to the state, but then you have specific obligations that have to be given effect to straight away, right? So these are high priority obligations. One might be the right to primary education. Another one would be, say, the right to emergency healthcare treatment. The idea is that these are things that have to be prioritised. And you see that approach, for instance, in the Kenyan or the South African constitutional models. Two more, right? And I deal with these very briefly because these are much more common, 1 and 2, than what you would see than 3 and 4. First of all, that all economic, social and cultural rights are subject to this general obligation, right? They all, it doesn't matter what the obligation is, it doesn't matter what the group is, all these rights have to be given effect to progressively, and they're limited by resources, right? So there's no mention of immediate obligations. And the fourth one is that all economic and social cultural rights, there's no progressive realisation. All economic, social and cultural rights are immediately enforceable for everyone in all instances. Now, I'm not familiar with the system where that is the case, and I think probably one can see why it might be, why there might be a certain reluctance to constitutionalise something that means that people can go to court immediately about any violation of their economic, social and cultural rights. But, I'm not steering you, I'm merely saying that it's an unusual approach. Conclusion, right, there's a lot of issues. I'd say at this point you're buzzing and desperate for coffee, so I'm going to talk for another 20 minutes. But no, I joke. But what I would say is we're seeing justiciable economic, social and cultural rights in more and more constitutions, right? But there is significant variety in first in the rights protected, and second of all, in the specific models of protection. And to go back to the question that was asked at the end, the balance that is being struck between the elected branches of government protecting and the courts protecting, right? So all I can say is it's a wonderful, chaotic area, and I look forward to hearing your discussions later. Thank you.
Thank you.